The Honourable Member for Nunavut.
I start by sharing that NDP support Bill C-11. I dedicate this speech to the victims of abuse in the military who deserve justice. Canadians who serve and have served in the armed forces and reserves deserve our respect and gratitude. Women, men, members of the 2S LGBTQIA+ community, indigenous people, racialized minorities have all served in our military. Too many of them have been subject to sexual assault. Too many have to endure racism, sexism, homophobia, and transphobia in the course of their service. Members of the Canadian Armed Forces put their lives at risk to defend our sovereignty at home and abroad. They and their families sacrifice so much in order to serve Canada. The NDP is committed to ensuring their health and well-being, their safety and protection. We advocate to ensure they have supports and services while serving and when they leave military service. The Canadian Armed Forces are important to keep our security and indeed our sovereignty. We are all shocked by the news stories of military sexual trauma, and we all want to see meaningful culture change in our military. I begin by sharing a historical perspective of why we support this bill. In 2015, Justice Deschamps issued her report with important recommendations. It took the Liberals years to respond. In 2022, the Liberals accepted recommendations in a separate report by Justice Arbour. Liberals told Canadians they would begin transferring all criminal sexual offense investigations to civilian courts. This is another Liberal broken promise. 3 years later, approximately half of the cases remain within the military justice system. Why? We do not know. There were many major problems with the cases that were transferred. Retired Corporal Ariana Nolet was one of the first military sexual trauma victims to have her case transferred to civilian courts. Unfortunately, her case was stayed due to time delays with the back and forth between military and civilian police. Since this incident, multiple other cases are stayed due to delays, resulting in the lack of justice for survivors. The cause of the delays were twofold. Number one, civilian authorities were wary of taking over the case, and due to concurrent jurisdiction, they were not mandated to accept the case. Number two, the transfer of case files by the military police were significantly delayed, causing commentators to speculate on whether the military police were unduly stalling the transfer. New Democrats continue to advocate for better outcomes for survivors of military sexual trauma. My friend and colleague, NDP MP Rachel Blaney, was responsible for the landmark parliamentary study on the experience of women veterans. They gave first-hand account of the horrific treatments they endured while serving in Canada's military. The study culminated in a powerful report in 2024 entitled Invisible No More. This report was the catalyst that finally pushed the Liberal government to act. NDP MP Lindsay Matheson undertook a summer of consultations with survivors and subsequently introduced a private member's bill. Bill C-362 would have immediately ended concurrent jurisdiction and ensured no future cases be caught in the tug-of-war over jurisdiction. Unfortunately, Lindsay's bill C-362, died on the order paper when Trudeau prorogued Parliament. Given the state of Bill C-11, the way that it was tabled, the following question must be studied at committee. To name a few, number one, This bill does not adequately address incidents in the reserves, the Navy, the cadets program, or international deployments. Why are they not included? Do they not deserve justice? Number two, survivors feel betrayed by the federal government. Survivors tell us they need more pathways to justice. They say pathways to justice will be taken away. What consultations included victims, and in what way are their voices included in Bill C-9? Number three, this bill may have the unintended consequence of creating a binary between criminal behavior and lesser forms of harassment, which may become more permissive and have less supports. What amendments will be needed to ensure victims of any abuse see the justice they deserve? Number four, since the sexual misconduct by senior leadership scandal, NDP's call to make the Department of National Defense and the Canadian Armed Forces ombuds and officer of parliament are amplified. This position must have the power to compel documents and conduct systemic investigations. Will other parties support amendments to ensure greater civilian oversight? Number five, amendments are needed for the new victim liaison officer. The commanding officer must not be the one to appoint the officer. Given that many cases directly or indirectly involve the commanding officer, we need to find an alternative to this proposal. The appointment must occur outside the chain of command. Further, parliamentarians need to review legal assistance for survivors and the independence of counseling services for members of the Canadian Armed Forces. Number six, the Prime Minister warned of an austerity budget. Expanding the mandate of civilian law enforcement without a corresponding increase to their budget will create problems. Indeed, potentially cost more. The November budget could include cuts to legal services and law enforcement agencies. This makes no sense. Will the budget further cut funding for the military police? Number seven, given the composition of the Canadian Armed Forces, investigations may include victims, witnesses, and others across multiple jurisdictions and potentially in secure military locations. A local police unit does not have the resources for these cases. It may be logistically difficult to recruit and deploy civilian law enforcement on an ad hoc basis. How will cases be investigated by civilian police when incidents occur across jurisdictions, especially for incidents that may occur during domestic operations, including routine operations in the North and Arctic Naval Coastal Patrols? What about incidents that happen abroad? What tools will civilian courts have in international deployments, Navy ships, etc., that cannot immediately be accessed by civilians? We need to ensure issues like custody of evidence are considered to avoid cases being thrown out. I appreciate the opportunity and I'm ready to answer some questions.